Do you think life is simpler as time evolves? For some, it can be more complicated when facing issues about health, estate plans, probate, long-term care, and more. That's why Attorney-CPA Joe Cordell hosts ElderTalk with TuckerAllen, providing intelligent answers for those thinking about their future. Here's Attorney-CPA Joe Cordell.
Welcome to another episode of ElderTalk. This week, we want to talk about, we actually are returning, Jill, aren't we, to a topic that we circle back to periodically, in part because it's a topic that I know something about and that...
just a little bit, right?
Just a little bit. And it is what TuckerAllen does. So I feel that when people watch this show, they expect to get some information about, how do you plan your estate? How do you think about your assets in the last third of your life? So we try to circle back periodically and talk about those fundamentals. So there is some repetition when we reach this topic because, the bottom line is, and the good news is that there's not a whole lot of complicated stuff to know when it comes to taking care of the essentials for the most important, one would argue, period of your life.
Right.
So the good news is it's not real complicated. There are some fundamentals, but you've got to understand what those fundamentals are.
And I think that's why it's so important that we revisit this topic because, we've learned mistakes can be made and there can be legal problems if estate planning isn't done right. And, I want to talk about why it's so important to work with an attorney as opposed to using an online legal service. I know it may seem more convenient, but you can run into some real problems.
Yeah, and it's true that, I'm an attorney, so somebody who's cynical may say, well, he's an attorney, naturally he's going to believe that. But I can tell you that I've come to know as a business person, as a family person, as somebody who tries to plan their lives just like everyone listening to this show, there are some things that you just don't do with a form and you don't cut corners on.
Right.
And I don't believe in giving money away to lawyers more than you have to. I mean, I hire a lot of lawyers. And I'm not talking about just lawyers for Cordell and Cordell or TuckerAllen. I'm talking about lawyers that represent me in various ways, whether it's business transactions, whether it's estate planning. I don't do my own estate planning. I don't think that doctors should treat themselves for the most part.
Sure.
I think that it's good to have people that you know and trust. And there are some things in your life that are really, really critical, and those are the times that you don't want to cut corners. And I would argue that when you're planning, your life after you retire, when you're trying to plan for a period when you may be at your worst, when you may not be capable of managing your life like you are now. In other words, planning for the most vulnerable period of your life, and then planning for the period thereafter. In other words, when you're gone, what's important to you. It's almost offensive to your loved ones to think that in an effort to save $500, if that's the number, choose a number, $1,000, you go online and you order a form for $25. I mean, what does that say? What's the message that's implicit in that to the people that you love when there's something so important at stake? So I'm impatient with my own family members in, for example, Kentucky, where I grew up, when I'm talking to my brother or others, and we're talking about things such as this, and the idea of a form might come up. Or I remember a conversation with my brother who doesn't have a lot of assets, but we're talking about whether he needed to hire a lawyer in his divorce. He was thinking there was some place you could go. I guess it was a mediator, and the mediator would hand you forms that you fill out forms, and you save, maybe $1,000. I'm not trivializing $1,000.
No,
but I mean, a divorce is one of those occasions when everything in your life is being divided.
Right.
Your pension plans, I won't even mention your children, but your pension plans, your real estate, your savings, your future income to some extent is going to be discussed at least. The idea that to save $1,000 you go to and get non-contested divorce forms when here's my argument to my brother. I said, if it's true that you don't have anything to argue about, that you've really worked it out, then that means that it really would have cost you maybe $500 with a lawyer in order to run that through properly and to have that lawyer call things to your attention that you would never think of. It's not the things that you think of, I think, that you're most likely to screw up, though you certainly can screw those up too because you're not a lawyer. But the worst thing about it is the things that could have been in your deal, things that could have given you advantages down the road or tax benefits you didn't even know to raise. And in their defense, your spouse, if they're as ignorant as you are and you're both doing this, then you both may miss out on things that could have been a double win. So,
well, this is a major life event, and you get what you pay for.
Yeah, you're right. And estate planning falls in the same category as, for example, a divorce. They're hugely important events. And the idea that you're going to try to save, even $1,000 is just not enough justification. There's too much on the table. So I'm impatient with my own family when I have this conversation and those avenues are considered. So I say sincerely to those listening that these are not occasions when you want to order a form. These are the occasions when, if anything, you risk overpaying for something. How many times have you overpaid for a car, for stereo electronic equipment, all the things in your lives you may overpay for? I admit that you don't want to do that. And if it turns out that when you died, there was these two occasions when you spent more than you should have, maybe you spent an extra $1,000 on your divorce or on your estate planning, I think that's an error you can live with.
Yeah.
I won't dwell on this. I hope I made my point. Whatever lawyers you use, try to use people who practice in this area. They're authoritative. Of course, I'm an advocate of TuckerAllen. But even if you say, no, I'm not going to use TuckerAllen, I want to use another law firm that I know about, fine. If they're familiar with this area of the law, then good. Go to them and don't begrudge the fact that they probably are going to charge you more than LegalZoom.
And they're going to be the one to discuss the fundamentals like durable power of attorney, having a will as opposed to a trust.
There aren't a lot of moving parts. Break it into while you're alive and when you're gone. So you first want to take care of while you're alive. So while you're alive, you need to allow for the possibility that you'll become incapacitated. I mean, instantaneously it can happen that way. So you want to plan for that. That means that probably a durable power of attorney, but you want to think about what those elements will be. It's not real complicated, but you don't want a form off the shelf because it may turn out that the durable power of attorney that you want is not like the one that was manufactured off of an assembly line for everyone else.
Right.
So there are things you can choose. You can choose, do you want it to be in effect immediately? Often that makes sense. Or do you want it instead to be what's called a springing power of attorney, which will come into effect when some event occurs, when you become incapacitated. And then you appoint the people to decide when those conditions exist.
So it's not like a one-size-fits-all.
No, absolutely not. And there are various things that you want to include. You may want to give authority to make some changes on your trust. And I'll talk about trust in a second, but a trust is often the centerpiece of your plan, both while you're alive and when you're gone. A trust in many ways should be the central character of your entire estate plan. And I think that in order to enable the trust to play the role that you want it to, sometimes you'll choose to give the person with the durable power of attorney who signs documents and things on your behalf,
sure,
who takes care of the business of your life while you no longer can, including in those hours and days after something happens when you need decisions made about bills that have to be paid,
right,
about medical expenses, about insurance coverage, all those things that require attention and decisions within that envelope of time after a crisis occurs that are the very times when you're powerless to be of assistance because you're in the center of things as a victim of this crisis. Whether it's a heart attack, whether it's a stroke, car accident, it can come in so many forms. So durable power of attorney is this marvelous tool that just allows someone to just step in without a court, without hearing, without lawyers and expense, and start doing the things for you that you would want done. So the question becomes, how much power do you want to give this person? And you want to give them a lot of authority because that's the whole idea is they can do that range, right, that range of stuff that you would do. But often many people would say, yeah, but that authority stops at the boundary between my life's daily business needs and my estate planning. And I get that. Some people, in other words, don't want this person to be able to tamper with their will. Well, that's by statute, actually, in the state of Missouri. Even if the authority is given in this document, you can't tamper with the will, even if you chose to sign a document to that effect.
Oh, is that right?
Yeah,
okay.
and which is good.
Yeah.
I would argue that as big a fan as I am of having a durable power of attorney, I don't think this person should be able to reach in and decide to reconfigure the beneficiaries in your estate.
Yeah, absolutely.
So that will be protected. But there's something that falls between those two distinct bright lines, and that often relates to the trust. And for some people, the trust is more like the will. They don't want it touched. They'll let you put something in it, but not take anything out of it, and not under any circumstance change the terms of the trust, because they see that as being the equivalent of changing the terms of the will. And I get that. So the nice news about a durable power of attorney is you can customize it. You can say, okay, I want to give the person that has this power the ability to reach in and to place money in my trust. I want to give them the ability to take money out to some extent. You can define that as a percentage, but certainly put in. And see, as long as you're just giving the ability to put in, and let's say no ability to take out, then that means that the beneficiaries stay the same. Now, I would typically suggest that you not give them the ability to amend the terms of your trust, because that, in effect, amends your estate plan.
Sure.
Because usually what will happen is a will dump any assets that were in your estate when you passed away. They'll dump it into the trust. That's often part of the plan. So in a backdoor way, if you let the person with a durable power of attorney tamper with the terms of your trust, then they've in effect changed your distribution plan.
Exactly. And when you're naming a durable power of attorney, isn't it a good idea to name more than one person in case the number one person that you named, for whatever reason, can't fulfill the duties, or perhaps they die and you need someone else to act on your behalf?
Yeah, it's critical. You're right. You want to have successor holders of the power. They're called an agent. So you want to name one successor, maybe two. So, and incidentally, there's all sorts of variety. If you want to have two people to hold this role simultaneously, it's a little risky if you acquire unanimity among them, meaning they always have to agree on everything. It's a little risky. Maybe I've had people who've had 3 daughters, for example, and all 3 are in St. Louis, and they feel, gee, I don't want to shortchange one of them, so I'm going to list them all in the durable power of attorney. So 2 out of 3 have to agree on any decision. Well, it's a little more clunky. You know, things don't move as quickly as perhaps they would if one person was making decisions and acting. But there's some sound reasons for that. I understand there are reasons that relate less to efficiency and more about honoring the respects and wishes of these people. So there are so many ways, as you mentioned, to do it, and that's one of them, is to give the authority to more than one person.
Now, can you give it to your attorney? Can your attorney act as your durable power of attorney? Your
attorney can. Now, I can tell you that at TuckerAllen, we prefer not to be the person acting in that role. We like to be in the role of the attorney and not be in 2 roles, being both the fiduciary and the attorney.
Sure.
It can cause conflicts of interest according to the way the rules of ethics in the law work. It's not forbidden, but we would rather have someone that the client trusts to be in that role. Now, my wife and I get that. We've chosen somebody who's an attorney to play such a role for us under certain circumstances. So I personally have confidence in some of the attorneys we know personally.
Right.
And I know other people do too. So I'm not telling them they can't use their lawyer, but their lawyer has to really think about whether they want to accept that role.
And that's an added expense if you do it that way, if you take that route. Is that?
Yeah. And that's a conversation that should be had. It's good you bring that up. Is the lawyer going to bill by their normal hourly rate for the time they take to do those things? And remember, that money's going to come out of your estate.
Sure.
It's definitely an important conversation to have. Some lawyers will probably cut back on their hourly rate playing that role. It's going to be very much a lawyer-to-lawyer thing. There's no standard answer to that. If there were a standard answer, I guess it would be they'd charge their hourly rate. But it doesn't mean that they're spending 2 hours a day. They may spend less than an hour a week, depending on what's involved. Mm-hmm. If, for example, they have to write a check or respond to an invoice, it doesn't mean that they are spending an hour to do that.
Right.
So don't think that if your lawyer is charging you their normal hourly rate to play that role that there's a good chance you're spending a ton of money. You can ask how much it'll be. You can get a projection, but I think you'd be surprised that it would be less than you think.
Sure. And I guess it depends on your own circumstances. Now, talk about the difference between a will and a trust. What exactly, for our listeners that may not be familiar?
Yeah, well, if they've been listening long, I hope they are familiar.
Yes.
But it bears repeating, and I always try to explain it a little differently, at least to make it so it's more interesting to people who've heard this before. You know, when you think about ways you can, first of all, handle your last years alive and then the allocation of your assets thereafter, one way to do that is with the durable power of attorney, what we've been talking about, except that really is just kind of giving someone a sort of blank check, except it's more than a blank check. It's a blank check allows you to have unlimited access to a single account. This durable power of attorney would give someone access to everything, including your 401k, your real estate. I mean, virtually everything you own is going to be available with this super blank check, you might call it. Well, there's no structure to that. And what is it that you want done? Well, the person can, on a case-by-case basis that you've given this power to, and I'm imputing to them the best of good faith, they still have to speculate about, gee, how would you feel about this, or how would you feel about that, or do you want your house sold? Is your house important for you to keep for your children? Rarely are there much instructions, if any, with the durable power of attorney. They're just not there. It's a tool that you pull out of the toolbox. It's generic. It allows unlimited access, and now you have to count on the judgment and discretion of the person you've given it to as to what your values are. That sort of loosey-goosey arrangement is often not satisfactory to people who are planning for this period of incompetency. And let's argue that it's more likely than not, I would say, that each of us will go through some period of time in which we're incompetent.
Right.
Now, maybe it'll be 5 years for some of us. Maybe it'll be 5 days for others. But let's not assume that we won't have a period of incompetence. Let's assume instead that we will. So we're talking about during that period of time, what do you want in place? Durable power of attorney works for all the reasons I've said. But I would argue that having a trustee who is responsible for everything within a trust, which is simply this way of organizing your assets. You can decide that you want to put your assets in the name of a trust, call it the Bill Jones Trust.
Okay.
And so you want to put your stuff in the Bill Jones Trust, and let's assume you're Bill Jones. You want to put your stuff in the Bill Jones Trust, and you get to write rules. That's what makes it so much more cool than simply having a durable power of attorney.
Right.
The blank check thing. Instead, this is where you say, okay, here's how I want the stuff in my trust managed. I want to keep my house. I want to do this. I want this to go to my loved ones. I want the beneficiary to be, as long as I'm alive, I'm to be the beneficiary. And that's what most people figure, is themselves and their spouse. They don't want their children to step in line as beneficiaries while they're still alive.
Still alive, right.
So what most of our clients do is that you have these tiers in a trust, and that makes it cool too, is you can plan into generations. And it's just a marvelous way to set out your values, your preferences, and have rules that you can be pretty darn sure the trustee is going to follow. In fact, the consequences are so harsh for somebody who is this type of fiduciary, who's a trustee, who fails to honor this relationship in the most good faith, conscientious way, is that there's an action that can be brought against them for which they can be held criminally and civilly liable by the beneficiary. So you have these people hovering around who are prepared to enforce this agreement, even if you weren't prepared to enforce it. So it's a marvelous tool to manage your stuff while you're alive in an organized way with a single set of rules, and then have it flow seamlessly after you pass away into someone else, the next tier of beneficiaries, call it your children, and for them to seamlessly step into your and your spouse's shoes literally the moment you pass away. Then all of a sudden those duties shift to the new tier, and the new tier is, call it your 3 kids, and they're getting the same sort of care that you've prescribed for them, and just like you prescribed the care you wanted for you and your spouse. It's so efficient, and there are no judges involved, no lawyers. Once this thing is created, it can just flow from generation to generation.
Now, let's go back to what you were talking about, the consequences and possible criminal charges. How would the heirs know exactly if everything's being carried out the way it's supposed to be?
Well, Missouri has adopted the Uniform Trust Code.
Okay.
And the Uniform Trust Code, it's this set of laws relating to how a trust should operate.
Sure.
That have been accepted in most states in the United States. More than 50% of the states have adopted the Uniform Trust Code. The nice thing is you're not inventing this will. This will came into existence about 700 years ago.
Okay.
And it came into existence, and it's been evolving ever since then. So there's a well-paved path of rules and suggestions to protect, as the question you asked, how do beneficiaries know? Well, that question has come up in the last 700 years when people create a trust for the benefit of people they love and care for, and then almost by definition, the people who created it are gone. They've died.
Right.
So now there's this third party that's supposed to run this thing for the beneficiaries. So the good news is, I'm not putting off your question. I want to instill your confidence that that one is covered, because we have found out over the hundreds of years that trusts have developed these rules that this is the way we assure they happen. And one of those devices under the Uniform Trust Code in Missouri is there's an obligation to inform a beneficiary that doesn't know of the existence of the trust. It's a duty of the trustee to inform the beneficiary.
Okay.
So they have to notify them that the trust exists and they're entitled to a copy of the trust provisions. They have to have accounting that occurs annually. It's not as if it's impossible for a trustee, just like anybody else in any position of authority, whether you're president of a bank or anything else. There's always possible that because of your position you can do things and possibly get away with it. But there are a pretty good set of checks and balances, not flawless. And that's where I will point out here a critical component of creating this trust is that you've not willy-nilly chosen someone to become the trustee. You've not sort of been indifferent about who that particular person was. Instead, you've been especially focused on selecting a series of people. You select the first person to be the trustee that you want to be alive in that role while you're alive. And that same person or persons, can be plural, will continue into that role even when you pass away if they're still living. And then after they pass away, you've chosen their successor. And then if you run out of people to name, you can always allow the last person to choose the next successor, which is an interesting way to solve that problem. In other words, you're saying, I trust my nephew, I know my nephew well, and I trust him, but I don't know if something were happening to him and he were dying or going to resign, who it should be. So I'm going to let my trustee pick who should be his trustee, because he'll be able to know and see opportunities for picking someone then that I can't see now. So that's another way of solving that. But other ways to address the thing you just raised a while ago, and that's that there's also a thing called a trust protector. This developed just in the past couple hundred years, where you can actually choose to place someone on the outside that doesn't have active duties of running the trust. So it's not like a trustee.
Sure.
But there's simply somebody that you know and you trust, could even be an institution like a bank trust department, and you say to them, you have the power of what's called a trust protector, meaning that you can drop in and look in on the trust and periodically and see if things are occurring the way they should. And if you notice that a beneficiary is not being contacted, or you notice that any transactions are occurring that appear to not be in the best interest of a beneficiary, then you're allowed to take action to replace that trustee or whatever authority you want to give it. So there are so many ways in which you can put in checks and balances in your trust to where it's not that you can eliminate the risk of malfeasance or wrongdoing, but you can come as close as any human institution is going to come by using the sort of experience that's been developed in trust law over this 700 years.
But what happens when this person isn't giving the heirs a copy of the trust, or showing them any accounting or anything like that, what happens then? What can the heirs do?
Well, it's not it would be the beneficiaries.
Beneficiaries,
Yeah.
okay.
So now remember, you have a bunch of beneficiaries. You have the current beneficiaries, the people who are entitled to get it now. And then you might have what's called remainder beneficiaries. These are the people that are next in line. Now, they don't get anything now. They're kind of like the kids of the kids. We'll call them the grandkids.
Sure.
So the grandkids are also a tier of beneficiaries, and they have rights too, even though they're not receiving anything now. But anyway, so the answer to your question is, well, if the beneficiaries know that they're supposed to be getting something, or they know they're named as beneficiaries, let's assume that much, then they can bring an action. They can bring an action in the probate court to remove the trustee. And they can remove the trustee for good cause shown. They can file an action to have a court settle a dispute. Here's one of the more common tensions that exist in trusts is that often you'll have an income interest, which is the first generation after the founders. So let's say that those of you listening, we'll call you the founders. So your kids, you might leave them an income interest, which means they have the right to receive the income from any assets that you have. Maybe you give them some principal and some income. So if you leave $1 million, you don't have to be real rich to do this, incidentally. $500,000, $600,000 or $700,000.
Okay.
Whatever. But the point is you might want to save some for grandkids. So sometimes there's this tension between what will be finally distributed as the assets and what's paid out in income. So sometimes if the goal is to maximize income, then the way the investment world works is if you maximize income, you've probably reduced growth. So sometimes there's tension in generations in trust between those who are ultimately going to get maybe whatever the assets are paid out at some point in the future, and those who are entitled to for their lifetime to get income from those assets. So sometimes you see that tension, and one or the other will go to court and ask the court to order the trustee to pay more to one generation or more investment for the future with the other. You occasionally have those things, but I'll tell you this, despite the fact that I mentioned courts and I mentioned causes of action and remedies, it's important that those all be there, but nobody wants to think that they've created something that requires litigation and lawyers and
Well,
expense.
sure.
And for the most part, it doesn't. I mean, that's the good news is it's really unusual. If you pick your trustee carefully, and I mean, it's not that you have to pick.
But we know that always doesn't happen, though,
No, it
unfortunately.
doesn't. It doesn't, but it can mean a lot. In other words, it's not impossible that your choice will be dishonest. It is possible they'll be dishonest. But for the most part, I'll tell you, of all the trusts that I've been involved with, 100 plus, I'm sure, I can tell you that very few of those have involved a dishonest trustee. Now, we've had trustees where there was a dispute about whether they should have do this or pay out that, but it's good faith. And the reason that's not so common is usually people are careful in their choices.
Oh, yeah.
They choose that child that they know is more responsible and maybe a little more conscientious than the others. So, but the good news is there are checks and balances. Going back to your question a while ago, who watches?
Polices?
Yeah, who polices the trustee? And that can be solved in a lot of ways. And I just mentioned a couple of those. The trust protector, I mentioned you name more than one trustee. It's another way to do it. It's far more difficult to get a conspiracy going than it is, for if you have one person doing it. And then finally, you can have just the beneficiaries. They're going to know they're covered. I mean, if your kids, all the kids and their parents create a trust, you're going to be suspicious if you're not getting any money from it.
And you mentioned you can go to probate court to have that person removed. Now, does that require that you hire an attorney?
Probably yes, but incidentally, if it's abuse, that money would probably be paid for out of the trust. Now, that's not necessarily good news if it's money that you would have otherwise gotten.
Right.
But still, if it relates to the management of the trust, then the trust should bear the cost of that responsibility.
Okay. And let's talk about what age would you recommend someone creating an estate plan? I mean, we don't think of someone in their 20s, but we know things do happen.
Yeah, I'm sympathetic with the person in their 20s who does a inexpensive will. I won't be harsh in my criticism of that. I understand that they recognize it's very unlikely they're going to pass, and besides, they have a they will be covered, though it's inefficient a little bit. And we have lots of criticisms of wills. Not because there's anything bad about a will. It's just that if you have any significant amount of assets at all, if you're above in the state of Missouri, I think smallest state administration now is you have to be less than $40,000. So if you're above that, then it's a good chance you're looking at having to probate the will, which means going down, opening an estate, having a personal representative appointed, having to marshal assets, notify creditors, go through the period of time that there has to be to reply to the advertising, 6 months or so. So you're looking at a year of being tied up in this way. It's just probate is better than nothing because it's there to see to it stuff gets passed to the right people after the creditors are paid. That's the fundamental idea, is to get your stuff to the right people after the creditors are paid. But there's just a much better way to do it. But to your question, if you're 25 years old, 26, 27, and you simply have a will, I get that. I wouldn't be critical of that. Now, when the time comes, though, you start accumulating stuff in midlife, I think that then you have to think about a more sophisticated plan. You probably have children then. You may have a spouse that's especially dependent on the other spouse's income. Now, the chances of you having a heart attack or lots of those hazards that we face more of as we age,
right?
They warrant your investing more into your estate plan. Then a revocable trust, yes, makes complete sense to me. It's a trust that you can amend over time. You don't start from scratch. So it's not as if you spend a couple $1,000 when you're 45, that then when you get to be 65, you have to spend another couple thousand to start over. No, that's not true. If you do it correctly, then you'll amend it probably when you're 65. You'll probably make changes to your trust. But that's a far cry from creating a new trust because now everything's digital. So when we create a trust, for example, at TuckerAllen, if a trust is created, then it's very easy to go in and change names, to change dates at which funds are distributed. Those things, take just moments to do. So we don't charge clients much for that at all, the time to go in and make those adjustments. If there's some fundamental change to the plan, okay, I get that. So you do spend a little more money. But don't think that if you invest more for your estate plan when you're 45 that you have to throw that in the trash when you're 65 and start over. That's not true. If it's planned correctly, a lot of the fundamental things, your children will have been identified. Even if they're not, they're referred to as children. So with the assumption that if you have more or one passes away, whoever the living children are, and then you have grandkids. So it's less to know about the names than what you want for your children.
And how often would you recommend reviewing your plan and updating it?
It depends on whether there's been a lot of change. I would say that every 5 years for sure. But if there is something dramatic that changes, a divorce.
Well, yeah.
I mean, things happen. If someone passes away, you may want to think about what are the implications for the gift that you had for that person. Did it call for it, if they're passed away first, for it to go on to their surviving heirs? Per stirpes is a phrase for that. And you may think it's not a good idea. Per
stirpes?
Yeah, sounds like a disease.
That's exactly what I was thinking.
Yeah. Well, the whole idea is that some people want a provision that if they have 3 kids, and they leave it to the 3 kids per stirpes. What they really mean is, in that case, is if one of the children have died, they want that child's share to go to their children. Because if they didn't say that, and the general rules would be that if you had only 2 children are surviving, then those 2 children get all the assets, right?
Right.
So if you don't say this phrase, per stirpes, then the result would be the grandkids of the deceased child, who arguably need the inheritance the most, would get nothing because it would all go to the 2 surviving children. So you can prevent that with phrases like that. So whenever someone passes away, predeceases you, that's in your plan, you may want to go back and think about how you'll reword those things. But absent that, usually every 5 years.
Okay.
Well, let's go ahead and take a break now. We have Dan, our roving reporter, coming in.
Yes, we do.
He has a cautionary tale for us this week, as is his wont from week to week.
Yes.
So we always look forward to these opportunities to learn. Why don't we take a break? We'll be back in a few moments. Another episode of Elder Talk.
You're listening to Elder Talk with TuckerAllen, providing intelligent answers for those thinking about their future. Sponsored by TuckerAllen, your estate and elder law advisors. And now, Attorney-CPA Joe Cordell.
Okay, we're back with Elder Talk. Dan, so you've uncovered another learning opportunity.
While there was a will in place for this situation, it's important to have people that you trust execute your wishes.
So let's start out with the basics of this case. This involves somebody who did some estate planning, a will apparently. He lived in Canton, Ohio. Tell us about this will maker.
Yes, his name was Philip DeCellis. He was the owner of Napoli's Italian Eatery and passed away at the age of 68 in July of 2016.
So he was pretty young,
Yes.
actually.
Overall, yes. He was a figurehead in the community, really driving the idea that there needed to be a lot of businesses in downtown Canton. He had 4 children and a stepson. His children, Anne, Mark, Michael DeCellis, Danny, and his stepson, Michael Skiba. 9 grandchildren, 1 great-grandson. However, Philip and his love interest, Patty, who in the obituary is listed as wife, never legally married.
But they had these, we think the kids were mostly from Patty, but in any case, he lived with Patty. He apparently treated her as his wife in many ways, but they were not technically married.
Yes.
Go ahead.
So in Philip's will, there was a plan laid out where Anne, his eldest daughter, was to serve as the executor. Patty was to get one of the houses on Lancaster Gate.
He owned several houses.
He owned 3 houses. Some of the business profits were going to go toward some of the bills at the house. There was one house and the restaurant property that were going to be split by the 4 children. And then there was a third house that was supposed to go to Anne, but she was supposed to allow her brother Michael to live there.
And then the rest of the estate was going to be divided.
Yes, among the 4
kids.
children.
So Philip, again, the person who made this will, envisioned that this apparently successful Napoli's Italian Eatery would continue to be operated by one of his sons, Michael.
Yes, Michael DeCellis.
Yeah, who apparently had an ability to run the restaurant, had been doing that for some time, and apparently this restaurant generated quite a bit of income.
Yes. Yes, there is quite a bit of income involved in this case. Patty and Danny, who were living with Philip, allegedly took $750,000 in cash that was supposed to be divided among the 4 kids.
Now, this occurred after his death?
Yes.
And then Anne also apparently allegedly took some money.
Yes, she allegedly concealed, embezzled, or conveyed away $388,000 from restaurant sales that should have been a part of the estate.
And it's interesting that he had all this cash just laying around.
Yeah, I think that's an important component to this. Talk a little bit about that.
Yes, so part of Philip's person, he almost exclusively used cash in both his personal and business dealings. He paid employees in cash. He carried around a briefcase with $20,000 at any given time.
Wow.
Yes. It's quite the characteristic.
Yeah, but now this is somebody who was not born in the United States.
No.
Even though he came here young, still he was born in Italy.
Yes.
So I wonder if some of this was just some sort of cultural or residue from his upbringing.
It could have been.
But it was a problem whenever he passed away. You have these assets floating around that can be so easily converted.
And hidden. And being the executor of the estate was doing inventory, logging assets, and all of that stuff. And she knew about the briefcases, lockboxes, and the safe. But when she went to go look at them, they were all empty.
And she was fully expecting to find lots of cash there, which there probably was, because they all knew this was the way he operated. Maybe he didn't trust financial institutions. So it's funny, though, that Patty and Danny, Patty is Danny's
Mother.
Okay, so they're living in the house and had the most opportunity. So we have to keep this as alleged, I guess, though a court did find that they had embezzled $750,000. Is that correct?
Yes.
Did I read that?
Yes.
So Ann comes into the house trying to undertake her role as executor, and of course checks all these places, and it turns out there is no cash there.
Yeah.
So what do you do when there's missing cash? It's hard to prove there ever was the cash because there's not the digital records or the paper records that you normally
it's not safely
associate.
in a bank.
Yeah. So there are no records of this money, and I think that whatever testimony the court relied on, they did conclude that there was $750,000 that was, what was the word, embezzled?
Yes.
Then Ann apparently also was accused of having concealed, conveyed, or embezzled a little short of $400,000 from the restaurant.
Yes.
Which, again, restaurants are notorious for, they generate a lot of cash, and sometimes the cash doesn't always flow through the register. So we don't know if Philip had been his operating style for years. We'll never know that. But clearly, it was an opportunity for Ann, after I assume Philip had passed away, to divert funds her way, but it was a violation of her duties she's a fiduciary, and a fiduciary is this very solemn role, and the consequences are harsher if in that role you behave in a self-interested or fraudulent manner, which is what she did, according to this court. Let's see, where is...
Yeah, well, it's interesting. Ann files the complaint against Patty and Danny in February 2017 because the estate is reportedly believed to be worth $1.5 million. And then Patty and Danny filed the counterclaim in spring 2018 accusing Ann of stealing the money from the restaurant. And then at the end of the whole thing, the court finds all of them guilty.
Yeah, that's right. This Judge Thomas Swift. So, he ruled embezzlement by Patty, Danny, and Ann. So Patty and Danny, they were to pay back $750,000 plus penalty and interest. That probably was significant. So it's probably north of $800,000.
Yeah.
Ann would have to pay back the $388,000 plus penalty and interest. So she's north of $400,000. She was removed, of course, as one would expect, from being the personal representative of the estate. So then they appointed this attorney, David Dingwell.
Yes.
So this matter is still going on?
Yes, it is. Dingwell initially filed a motion in closing the estate because he thought that it would never be paid back. Because it wasn't flowing in anyways. They weren't making any efforts to pay it back. And he didn't get the sense that it was going to be paid back.
So let's summarize. We only have a few moments here, but
Okay.
But when we talk about these things, it's kind of fun to talk about these things. There are lessons here. And when you think about Philip having a plan for his family, which obviously he cared for very much, I think his family was a very big part of his life, and yet this train went off the track in a bad way. The observations I'd make is, one, you can love your kids and still have an understanding for who and what they are. And I would suggest that he probably knew something about his kids.
Yeah.
I suspect that he probably would have said that they might be inclined to try to advance their position to the detriment of the others if they could. So when you have children like that, you don't want to put them in positions of authority. You definitely don't want to leave cash lying around that makes it just tempting to help yourself to that. And he apparently lived that way for whatever reasons, but that was no way to conduct his plan. So the assets should have been in a financial institution where there's a record, a digital record that's not going to be tampered with. And in this case, it's going to always be a mystery as to exactly how much money there was there.
Yeah.
In this case, also, there's the fact that the people who took the money can never repay it, or it looks like they can't. So here's the way that this could have been handled. It could have been handled that the assets were placed into a trust we were talking about earlier in the show.
Yeah.
A trust, imagine this as a perfect solution for this scenario. So the assets would be held through the trustee, through an individual acting as the trustee of the trust. That means that none of the assets could have been conveyed without his authority, for which there would have been a record.
Right.
Again, this assumes the cash problem is solved, too, by having the money placed inside financial institutions and the name on the account being the trustee. So you choose a trustee. that you can require to be bonded if you have some distrust. I can tell you most of my clients don't do that because they pick their trustees carefully. And if Philip had good judgment, he probably could have chosen someone who he could trust. But it's not just about trust with the trustee. I mean, they do have checks and balances, as we talked about earlier. But still, it's a wonderful start, particularly when you look at this disaster, this train wreck, to come out of the station with a trustee in charge of all the assets and have them all accurately accounted for. That's a huge advantage. In this case, the will probably wasn't the right way to do it. It waits until he's gone, and when all the mischief that can happen that might not have happened occurred in his presence.
I think mischief is the right word in this case.
I would say if I pointed to one single thing that would have averted much of this, it would have been to create a trust, place the assets in the trust, of course get the cash into financial institutions where there's a record, and choose well your trustee, and then give them the authority to carefully hand out the assets after proper valuation, et cetera. A good cautionary tale. So I look forward to our getting together next week. We'll continue to talk about things of interest to you and your lives. Another episode of Elder Talk. Till next time, take care.
You've been listening to Elder Talk with TuckerAllen, providing intelligent answers for those thinking about their future, with Attorney-CPA Joe Cordell. Sponsored by TuckerAllen, your estate and elder law advisors. For more information, visit TuckerAllen.com. Listen again next Saturday for another edition of Elder Talk with TuckerAllen. The choice of a lawyer is an important decision and should not be based solely on advertisements.